Okay, there you go. Well, I want to welcome everybody this morning. My name is Marty Mascari. I work as a contractor under the North Central Texas Council of Governments under the Area Agency on Aging. And part of what we do is put on free webinars or training events in this COVID environment. It's mostly webinars, but for caregivers. Our primary audience is caregivers of older adults, family caregivers of older adults, family caregivers of persons with disabilities, but we also are, thanks to Haiman+Hogue, are able to offer CEUs for these for professionals, and we love to have your professionals on as well. And we'll talk about the CEUs here next. I'm going to go ahead and let you do that if you'd like, Sheila. Do you want to cover that real quick?
I would love to. I would love to. Good morning, everybody, and we're so glad you could join us. I know this is earlier than we normally do, but that is great because then it sets the tone for the rest of your day. So here is what we offer these CEUs to train you, help educate you, to help you help our seniors. Okay, because that's all we're trying to do here. Now, it's very simple when you, well, first off, this is good for any nurse, any licensed professional counselor, or any social worker, or any assisted living manager as well. So any of those professions can receive this credit. It is good for 1 hour of credit, and I will be happy to send those to you. When you send, after the end of this, if you send me an email at sheila@haimanhogue.com, which I put in the chat, then I will be happy to send you the eval form and the sign-in sheet. Simply return that back to me by email or scan it in, either way, and I will send you your certificate.
Very, very good. You know, I obviously had mediation on my mind when I was doing this. I had just done the mediation slide, so you'll see on the slide, I used mediation. It's really, I'm sorry.
That's okay. That's okay. They're like, mediation? What is
we'll do mediation next month, y'all, and then y'all can do those. But guardianship is this month. Sorry about that. And I guessed on the date just because and so that's the date I guessed on. I didn't know what you wanted to use as the final date, but. Okay, so let's move on, and we're going to welcome Fred Haiman with Haiman+Hogue, and he's our speaker today, and he's going to talk to us about guardianship in Texas. Fred, it's all yours.
Well, thank you, Marty. I appreciate it very, very much. Yeah, this is one of my favorite topics to talk about because it's one of the, I think, least understood areas of elder law, and that's dealing in the area of guardianship. To give you a little bit of my background, I was a police officer for 5 years back down in El Paso, Texas. So I understand we got some El Pasoans on there. So welcome. It's good to have you. I was a police officer there before I went to law school. And then when I got out of law school, I was a trial attorney for about 10 years, did some civil litigation work. And then I switched over to elder law and estate planning in 2007, 2008. And I've been doing that ever since. We have a law firm here in the DFW area, office in Frisco and Arlington. And this is exclusively what we do. We do nothing but estate planning and elder law. And elder law encompasses guardianship. A lot of people hear the term guardian or guardianship and they automatically think of children. And the reality is guardianship has very little to do with children in Texas. Most children have to be dealt with through the family courts in a thing called conservatorship. And some of you all that may be from another state other than Texas or have been from other states, it's the opposite because some other states have elderly dealing with conservatorships and children dealing with guardianship. So it really all depends on the state that you live in. But what we're going to talk today about is the guardianship aspect of Texas that deals with taking care of somebody that cannot take care of themselves. So this is, we're going to see some terms and all, but it deals mainly with a concept called an incapacitated person. And one definition of that is children. So children under the age of 18 are considered incapacitated and needing of assistance. But the majority of the work that we do deals with adults, either an adult, 18-year-old that is special needs, that now, mom and dad or somebody has been taking care of them their whole life, and now they're 18 and they're considered an adult under the law. So they need somebody to continue to take care of them. So we do guardianships for them. We do guardianships for people that are in traumatic injuries or illnesses, traumatic brain injury, military that have gone off to war and been hurt. Those type of people, or people in car accidents is an unfortunate common one. And we do a lot of these for people in the elderly area, dementia, Alzheimer's, Parkinson's. So that's really what we're going to focus on today. I'm going to focus on what it is, what we're looking at, and what some alternatives are that we can try to avoid it, because guardianship is one of those processes that we want to avoid at all, if at all possible. There are times when it can't be avoided, but we want to avoid it if at all possible. So next slide, please, Marty.
I'm sorry, I'm having a little bit of trouble getting it to advance. Hold on.
That's okay.
There we go. Oh no, it's going backwards. I apologize.
That's okay. We'll get it all down.
Just as one to get. Okay, come on now.
I've come to the conclusion that sometimes I have one Monday a week, and then there's other times I have 5 Mondays a week. So this is just.
I am going to there we go. Sorry.
There we go. Oh, okay, so we covered a little bit of this already, but the objectives of today's presentation is to talk about what guardianship is in Texas, what's the important terms revolving around guardianship, the types of guardianship there are, because there are different types of guardianship that you need to know about. What are the proceedings? What does Texas law say about it? What are the pros and cons? And that's a long list of what the good things about guardianship and the not so good, what alternates are, and why you want to avoid guardianship. Next slide. There we go. And go ahead and on to the next one. One more. Okay, so this is a definition of guardianship. Guardianship is a court-supervised administration. So the one thing you have to remember about guardianship is you cannot do it without going through the courts. You cannot appoint somebody or become a legal guardian without going through the courts. And the court that it goes through is the probate court. So in counties that don't have a designated probate court, it may go through a county court or district court, most likely a county court or county court at law. But in the bigger cities like Dallas, Fort Worth area, Tarrant County, Dallas County, Collin County, Denton County, El Paso County, and other Houston, around San Antonio, some of those bigger counties have designated probate courts. And the probate court's entire purpose is to deal with guardianships and deal with probate matters. So what we're looking at here is we're looking at a person that needs to be taken care of, a person, a guardian for somebody that needs to be taken care of. So the guardian is the legal person appointed to take care, and the ward is the person that needs to be taken care of. Next slide. It's a relationship established by a court of law between the person, the ward, and the guardian. Next slide. So those are two important terms that you're going to need to know, and you'll hear quite often, is guardian and ward. Guardianship involves, as I said, adults much more often than it does children. Next slide. Typically, the only time a guardianship is necessary for a child is when there's money involved. And I've had these happen. I had an unfortunate situation when I used to practice law in El Paso. They went through a time where there was a lot of killings across the border in Juarez, a lot of cartel killings. And unfortunately, it was good for my business because I did a lot of probates and a lot of guardianships. But I had one case where a mother had been killed in Mexico, and she had a big insurance policy, hadn't left proper beneficiary designations. So it went to her 3 children. All 3 children were minors, and the biological dad was not married to mom at the time of the death. And he had to apply for guardianship for his own children so that he could manage their money, because he didn't automatically get a right to manage the money for them. So we had to set up a guardianship for him to manage the money for the children. But we also see that with lawsuits and other issues where children inherit money. Next slide. And one more. Okay, so I'm going to go over a few of the important terms. There's really, hundreds, dozens and hundreds of terms involving this. I'm going to try to cover some of the ones you'll hear of more often. But a certified guardian is a person certified by the commission, the Texas State Commission, to provide guardianship services in Texas. A certified guardian is usually a professional that is not related to the family and is appointed by the court to take care of somebody that needs to be taken care of. A family member that becomes guardian gets certificates of guardianship, but a certified guardian is a professional commissioned by this or licensed by the Commission of the state of Texas. Next slide. A corporate fiduciary, these are people that manage money for guardians. These are usually your trust companies or other companies that are in the 100% business of managing money. Their job is to manage it and hold it and invest it and make money for the benefit of the ward. And then the guardian has to work with this corporate fiduciary to be able to pay bills and take care of things. Next slide. Engaging in the business of providing guardianship services. This is the companies that do professional guardianship services. I have not found a whole lot of them in the DFW area. I missed that from when I practiced law in El Paso, because El Paso had professional guardianship services that I worked with on a daily basis, but they also had professional nonprofit services for the lower income. There's a thing called Project LULAC in El Paso that provided guardianship services for people that didn't have family members and didn't have the money to pay for it. And their fees were actually paid through the county. I have not found that in the DFW area, and it's sad that we do not have the services like this that we can go to when we have somebody that needs to be taken care of, but they don't have a family member or somebody else that can do it. And especially when they don't have a lot of money, they're lower income or they're living on a fixed income. It's very difficult finding people to do this. Next slide.
I'm so far sorry. This is just giving me fits of, and you know what? I'm going to pull it out of this mode and try it in a different mode if I could.
I can try it.
Escape.
Okay. I understand you all are having a little bit of trouble hearing me. So I'm going to see if maybe we can get a mic and see if that helps a little bit.
You guys might also check your sound, because I'm not having any problems at all hearing Fred, and so it may be something on your end. If you could check your sound as well on your end. I know we had this problem yesterday, and it ended up being on the user's end.
Okay.
But Fred, I'm just going to try to do this in a different format. I know it's not as easy for everybody to see, but it's really giving me fits about advancing the slides.
Okay, and this is better because that way you'll see the slides. You all will get a copy of this entire presentation, so you can go back over it after the presentation. And if you have any questions, you guys can reach back out to us, and we can cover whatever we need. I'm trying to hook up this mic just to be safe. If I do hook it up, if you guys are having problems, let me know. Marty, can you?
I could hear you till you just said that, and then I lost you there.
How about right now?
I can hear you there, but
Okay.
I could hear you fine before, so I'm not sure that I'm the.
Okay, well, if you all are having trouble hearing, please let us know, but hopefully this will make it a little bit better.
And just so you know, in the chat, I'm just pasting right now the link for the slides. I know some people have asked for the slides. I wasn't able to access it when we were in the other format for the slideshows. So go ahead, Fred. I'm sorry.
So back to our definitions. The definition of a guardian: a person appoints a guardian, a successor guardian, or a temporary guardian. There's three kind of categories of guardian. A guardian is permanent. So we do permanent guardians where the person is appointed until a court says otherwise. We have successor guardians, and that's typically, again, requires a court process. where we have to go in and say, court, judge, the guardian can no longer serve. We need another guardian to step in. And then there's the temporary guardian. And the temporary guardian is quite often used in emergency situations where we need to get somebody in place as quickly as possible. And then we will convert that to a permanent guardianship later. As you can see, the guardians fall into two categories, the guardian of the estate and the guardian of the person. And the easiest way to understand that is that the guardian of the person is like a parent. Their job is to take care of the person, make sure they have housing, make sure they're warm and they're kept in a good place, make sure that they take their medicine, they get fed, and they go to the doctor. A guardian of the estate is like Bank of America. They're the fiduciary over money, and they're responsible for taking care of the person's money, paying their bills, taking care of them to use money for medical purposes or whatever the case may be. They have to keep track of all of the money that comes in and goes out, and they have to look at the money in the best interest of the ward. Next slide. So I'm gonna go these real quick, guardianship program and guardianship services. I'll let you guys read these after the presentation, but these are just some various things that fall within the guardianship arena. Next slide. So the guardianship comes under Texas Estates Code 1002.017. If you've ever seen the Texas Estates Code, it's about, I'd say 3 or 4 inches thick. It's got all the laws dealing with probates, heirships, and guardianships. And it's the one that determines what a guardianship needs, what it takes to qualify as a guardianship, and all the definitions. And this is the definition of an incapacitated person. And as I said at the beginning, one of those definitions is a minor. And a minor in Texas is somebody that has not turned 18 years of age. So anybody under the age of 18 is technically considered incapacitated. That's why 16-year-olds can't get married without permission or special circumstances. They can't enter into contracts and buy their own car and enter into a mortgage. They cannot agree to a lot of things because they're considered incapacitated and not able to make smart decisions for themselves. The incapacitated people we deal with the most is the adult area. The adult person that has a mental condition that makes it to where they can't provide their own food, clothing, shelter. They can't care for themselves either physically or financially. And this type of person must have a guardian appointed them to receive funds from any government source. So some of you out there might be aware or might even be a designated payee under Social Security for somebody you're taking care of. I am in the middle of living what I do for a living because I am a caretaker for my 89-year-old mom. And I am her power of attorney for all of her needs, both healthcare and financial. But I am also her designated payee for her Social Security benefits, as well as her military benefits she gets because my father was a veteran. Next slide. The ward is defined under that section 1002, and it's a person whom a guardian has been appointed. So you're not technically considered a ward until you have been appointed by the courts a guardian to take care of you. We always say it's the proposed ward or somebody that is in the works. Code of Ethics, private professional, and certified guardian. I'll let you guys look this over. These are just some other definitions I thought you might need to know, as well as the next slide, Marty. And I think those are just, supervisor and volunteer. These are ones you don't deal with as much, but it talks about people that are appointed by the commission or the Department of Aging and Disability Services to take care of people that need caring. So what are the types of guardianships? I mentioned already, they fall into two categories. The guardian of the person, a guardian appointed to take care of the physical well-being of the ward, and the guardian of the estate, the person that needs to take care of the ward's money and other assets. Next slide. So the types of guardian proceedings that we go through, and these, what I mean by proceedings are court proceedings, the legal proceedings that you have to go to. First off, we talk about the emergency guardianship, and we see this quite often. These are people that all of a sudden things have gone south and they're being either taken advantage of physically, emotionally, or financially. and we need to do something immediately to get them taken care of. The drawback of dealing with emergency guardianships is that it depends on the court that you're in. And this is the one thing I always say about everything that we do for a living. If you can keep out of court, then do so, because there's a lot of negative when it comes to court. And one of the negatives is you don't know the judge you're going to be dealing with. And it all depends on the county you're in. Some counties are better than others. Some judges are better than others. We had a situation in El Paso many years ago where we had a judge on the probate court bench who didn't know what she was doing. And we were trying to do an emergency guardianship because the lady was being taken advantage of and her money was being taken, and she was giving money away to these scammers. And the judge absolutely refused to do an emergency guardianship and actually told us, just get her checkbook, have her sign as many checks as you need so you can pay her bills and you can take care of it that way. And we said, Judge, that's exactly what we're trying to avoid. We don't want her to be signing blank checks for anybody to be able to get a hold of because she's being taken advantage of. And the judge absolutely refused to do an emergency guardianship. We proceeded on with a full guardianship. We transferred it to a different court, and we were able to get this person taken care of. But you just don't know what you're going to do. And I can tell you, Dallas is different than Tarrant, is different than Collin, is different than Denton. Every judge is different in this regard. The next type of proceeding is the temporary guardianships. Now, these are usually emergency. They kind of fall into the same category, but they don't have to. A temporary guardianship is somebody that we got to tell the judge, okay, Judge, we want to get a guardianship just for a little while until we can figure all this out. We want to make sure that the ward is taken care of. And that's the one thing you cannot forget. The focus on these proceedings is the ward. They don't care about family. They don't care about the attorneys. They don't care about who is happy and who's not. They care about the person that needs to be taken care of. Are they going to be taken care of? And do they need to be taken care of? And do we need to go to the extreme of a guardianship to do so? So it takes less evidence to prove up a temporary guardianships. They're usually limited in duration or type. And they offer a transition into permanent guardianships, and they protect somebody usually in immediate danger. We do a few of these. I wouldn't say they're real common. I say the more common are emergency, which are still part of the temporary, but they're emergency, and then they go to permanent. Next slide. So the permanent guardianship is a guardianship that means exactly that. It is in place until something is legally done to change that. So a person will remain a guardian and the person will remain a ward as long as need be, as long as they file the yearly things that the court requires, until the court comes in or somebody else comes in and says, this person doesn't need a guardianship anymore. I've done those to where the person got better, their health got better. They got to the point where they could take care of themselves. And we said, you know, Judge, we need to take the guardianship away because they can take care of themselves now. Unfortunately, that's not real common, but it does happen. Another permanent guardianship, and it's really kind of it's closed, but it's really not. And that's when somebody moves from one state to another. Whenever you move the ward to a different state, you have to dismiss or cancel or end the guardianship in the state that started and transfer guardianship to the new state. It's a special process and it requires an attorney. All of these things require you to have an attorney to do it. You can't do it on your own. They're so complicated. But a permanent guardian, again, remains in effect until the court says otherwise. So these are some of the things that can end a permanent guardianship if the guardian fails to file the annual report or becomes disqualified for some reason. Now, annual reports fall into two categories. One is a report on the person. So you have to file a well-being report of how this person is doing. And you have to file an accounting on the finances, telling the court where the money is, what's come in, what's gone out, what it's been used for, etc. If that is not filed on a yearly basis, the court can terminate the guardianship. If the person becomes disqualified, and what I mean by that is in order to be a guardian, you have to qualify. And two of the disqualifiers, there's others, but two of the big ones, or you cannot be convicted of a felony or a crime of moral turpitude, and you can't file bankruptcy. The bankruptcy one isn't an automatic disqualification, but it quite often is pretty much automatic because the courts aren't really likely, especially to appoint somebody as guardian of the estate if they are in bankruptcy. But a felony is. So if a guardian gets arrested and convicted of a felony, the court can remove them and can cancel the permanent guardianship. But more likely than not, the court will just appoint a successor guardian. So the court-ordered guardianships, as I said, it automatically expires 1 year and 4 months from the date of issuance unless the court renews it. So one of the negatives you'll see me talk about later of guardianship is it has to be kept up with every year. And those are legal fees and accounting fees that have to be done. So this is not a cheap process. It's not uncommon for a guardianship to run $10,000 to $15,000 to start and go up from there. And then there's yearly fees on top of that every single year. Next slide. So let's talk about this Texas laws relating to guardianship. Qualifications of a guardian. As it says right here, one of the things a guardian has to do is take an oath. They have to provide a bond. A bond goes in line with what assets and money the ward has. So it's a security, an insurance policy that secures the ward's money from being misappropriated. And if it is, then the ward is made whole. So they have to secure a bond. You have to file that bond with the court. The judge has to approve the bond. It can't, if the judge will only do it from certain companies that usually do a lot of guardianship type bonds. And you have to take an online training to get a certificate to be able to say you've been trained to qualify as a guardian. Attorneys are the same thing. Attorneys have to have, I think it's 3 hours, and correct me if I'm wrong on that, Jeff, 3 hours of training to be certified to do guardianships. Not any attorney can just do a guardianship, so you can't hire just anybody to do it. The attorneys that handle these guardianship cases have to go through the training. Is it still 3 hours, Jeff?
Yes, it is.
Okay, and it's through the State Bar of Texas in order to be certified.
Yeah, it's basically CLEs that are qualified for guardianship certification credit.
Okay, great. Thank you. Next slide. So people statutorily ineligible to be appointed a guardian include, next slide. And I love some of these definitions. People, of course, a minor cannot be a guardian because they're an incapacitated person themselves. But I love this second, people whose conduct is notoriously inappropriate. And I took that right out of the code. Now, if anybody can give me a specific definition of what exactly notoriously inappropriate is, please do, because there isn't one. It's kind of a case-by-case basis. The court determines whether their conduct was inappropriate. Some of us know what, there's some that are real clear. So if you've been charged and convicted with child molestation, I think we can all say that's notoriously inappropriate. But there's other conducts that are borderline. If the person gets a DWI, or if they get more than one DWI, is that inappropriate? Some of those are a little iffy. An incapacitated person of any kind, of course, can't serve, and a person who is a party or a party to a lawsuit concerning the ward. And we see this with family members. So there's a family member who has a financial interest for some reason because of a lawsuit pending or whatever. If you have a financial interest of any way, shape, or form with the proposed ward, the court won't let you be appointed. Or if you're indebted, you owe money to the ward. And we see that sometimes where a child will want to be guardian for their mom, and other family members will bring up, but wait a minute, mom lent this child a lot of money, and that child hasn't paid mom back like they were supposed to. And that's not really, fair if she can take care of mom's money. So that can be a disqualifier. Next one. So a person asserting a claim against the ward or the ward's property, or so saying that the ward owes me money, that would disqualify me because of this is another very, very, very broad one, because of inexperience, lack of education, or other good reason. So this 7, I call a catch-all to give the court permission to disqualify somebody for anything they want to possibly disqualify them for. It doesn't take much to meet this definition if there's anything that's happened. A person, corporation, institution found unsuitable by the court. I've never had that personally happen, but I guess it'd be corporations that may be in Chapter 11 bankruptcy, for instance. Person disqualified because of prior incapacity, that can be an issue. Jeff, have you had any experience with any of these that we went through?
Yeah, I do actually. Item 8 refers to a person found unsuitable by the court, and this can sometimes be a problem when you have a contested guardianship, because obviously when you have family members that disagree, they will sometimes do and say whatever they need to say to get what they want to get accomplished. And so this unsuitable is really a ripe area for controversy. When you have family members that are alleging that each of them are unsuitable, again, it's in the eye of the beholder, and obviously the beholder is the court. So sometimes that's creates a lot of problems. You have to have hearings to determine, for the court to determine whether someone's unsuitable or not. That's where I see most of the issues coming up, is in contested guardianships.
Well, and I agree. The ones that I dealt with all the time were family members that were fighting over who should be the guardian. And my experience was that if that happens, the court 9 times out of 10 will say, then neither one of you are going to be guardian. We're going to appoint somebody else. If you guys can't get along, then you're both unsuitable. And they don't even have to have other evidence other than that, other than you guys can't get along. That's been my experience. Next slide, please. So some pros and cons. This is a pretty good list, so we're going to go through these rather quickly. Some pros of making sure the person is protected. We want to make sure we protect the vulnerable. We want to help the ward with personal and financial affairs. We want to give the ward an advocate, and we want to protect them through court supervision. The court oversees everything. But on the negative side, it's more restrictive than anything else that can be taken. So quite often the courts will say, have you tried every other measure before getting to this point? Because this is the last avenue that we want to take. If the ward loses, another con is the ward loses numerous rights. One that comes right to mind is the right often to drive and the right to vote. And I've seen a court, I had a case in El Paso where we were trying to take care of a lady with her estate planning documents that she had in place. She had gotten to the point of Alzheimer's, for what we call paranoia, where she was paranoid of everything. She thought her daughter was out to get her and was stealing all her money, which wasn't true. And we were filing a guardianship. The court used this to convince the ward to not to allow her daughter to take care of her, to keep from doing a guardianship. And in essence, what the court said is, Mrs. So-and-so, I understand you don't think that your daughter is taking care of your property, but there's no evidence to show that. And since you have all your estate planning documents in place, you need to let your daughter take care of you. And if you don't, I'm going to have to put you under guardianship. And if I do, you're going to lose your right to vote. And he said, Miss So-and-so, you don't want to lose your right to vote, do you? And of course, like a child, quite often like a child, she's like, no, I don't. He says, then I suggest you let your daughter take care of you. And we were able to avoid guardianship for about another 6 months until her health declined. And then at the point it declined, I called the court. The court automatically gave us a guardianship without even having another hearing, because we put it off as long as we could. It may take family out of the process, and it may limit family members' access, because especially in contested issues where families are fighting, I've had courts come in and say, okay, you guys can't get along, then neither one of you get to see her. Until you start acting like adults, I'm not going to treat you like adults. And I'm going to ban both of you all from going to the nursing facility or the assisted living facility or I'm going to make it supervised visits, things like that. Next slide.
Can I jump in here real quick on this? One thing that you need to keep in mind about the guardianship process is, because you do take away the ward's rights, the courts are sometimes very hesitant to do that without a very fulsome showing of everything that could be done to help them short of guardianship, and that you've considered all of those alternatives, those lesser restrictive alternatives, before going through guardianship. It's going to depend really a lot on which court you're in. which probate judge you're in front of, which county you're in. Some judges are very, very hesitant to grant guardianships, and they require a very strong showing of less restrictive alternatives being considered and found to be infeasible. So just know where you are, know what judge you're going to be in front of, hire somebody who knows what they're doing, knows what that court requires, because that can become a fairly significant sticking point in depending on the court that you're in.
And we're going to cover those alternatives at the end of this presentation. So you'll see some of those objectives. So other pros, it requires a licensed medical professional to certify that this person is incapacitated, and the court has to look at that and accept it. There is legal recourse if anyone does anything wrong to the ward. So again, with the court being involved, if something goes wrong, the court can step in and do something about it. Cons on the other side is it's a humiliating and time-consuming process. It is very tough on the ward, it's tough on the family, it's tough on everybody involved. It's a long, drawn-out process. Even once the process is done, as I said earlier, there's yearly requirements, so it's almost like it never ends. I have some cases that I did in El Paso back in 2006, 2007, 2008, that I'm still getting emails from the court on things that are still going on in that case, even though I'm not involved in them anymore. Court has the continued involvement of the annual reports, the annual accountings, etc. Now that's a pro and a con, because we want the court involved, but again, when the court's involved, it's a pain in the rear. Next slide, please. It gives the ward a strong support system. It can give the family members peace of mind, and letters of guardianship have to be done yearly, so they're held accountable yearly. Cons on it, though, is the ward might fight the process, especially if their mind is not right. With Alzheimer's issues, we see it a lot, where they don't want to be under guardianship. They don't want somebody to take care of them, or they don't trust somebody to take care of them, and they will fight the process. And if they fight the process, it becomes difficult, because one of the things that's required in a guardianship is that the court appoint the ward their own attorney, called an attorney ad litem. That attorney's job is to look out for the best interest of the ward and to present to the court what the ward wants. And so if the ward is telling this attorney, I don't want a guardianship, even if that attorney knows they're not quite right-minded, that attorney has to advocate for the ward, and it becomes a very difficult issue. As you can see, I put both a pro and a con that the letters have to be done yearly. It's an accountability thing as a pro. It's a nuisance as a con. You have to do it every year, every year, every year. Next slide. It makes it easier to get things done once you get things done. But as you can see, I got a lot more cons than I do pros. I got nothing else on the pro side, because con is it's terminating or modifying it can be extremely difficult and expensive. Transferring it can be difficult and expensive. And it's overall a very, very, very expensive process. Next slide. So why is it expensive? There's legal fees, there's court costs, there's court appointed investigator fees sometimes, there's attorney ad litem and guardian ad litem, and those are two different things. The guardian ad litem is kind of like the guardian of the person, taking care of their well-being. The attorney ad litem is the person that looks out for their legal needs. Next slide. There's also the medical assessment fee. As I said, one of the pros is that a medical assessment is required, but doctors aren't free. And typically those medical assessments can be $1,000, $1,500. And the person filing has to pay for it, or it comes out of the ward's proceeds if they have proceeds. But that is a big fee. There's sometimes appraisal fees if the ward has some assets of value, especially if we have things like collectibles, antiques, things like that. There's costs of notifying all the family members, because that is a requirement to notify everybody that could possibly have a say-so in this person's life. And then there's a lot of administrative fees like bond premiums and ongoing court costs and clerk fees and accounting fees and additional legal fees that keep going on and on and on.
Hey, Fred, can I jump in real quick?
Go ahead.
Going back to your discussion about the attorney ad litem and the guardian ad litem, One thing that sometimes happens is the court will appoint both in a guardianship case where there are some issues going on. And it's a little bit of a distinction, but the attorney ad litem's job is to advocate for what the ward wants. So if mom doesn't want a guardian and tells the attorney ad litem that, the attorney ad litem's job is to advocate that position to the court for mom. Where you have a guardian ad litem appointed, the guardian ad litem's job is to act as an officer of the court and advocate for her best interest. So if mom doesn't think she needs one and the attorney ad litem is arguing that to the court, the guardian ad litem thinks she does. The guardian ad litem is going to tell the court that they believe it's in mom's best interest to have a guardian, even if mom doesn't think she needs one or wants one. So it doesn't come up a lot, but I have had cases, even a recent case, where that has become a big issue. And we've had a attorney ad litem and a guardian ad litem actually disagreeing on what the court should do.
Mhm. And again, it depends a lot on the court, but I've even had courts where I was an attorney ad litem and my client, the ward, didn't want a guardianship. And the judge says, you know, let's take a recess, let's meet in my chambers. And in chambers, the judge would ask me, all right, now tell me the truth. I know you're advocating for your client, but does she need a guardianship? And so every court is different in the way they do that. That's why it's so important to have attorneys that know what they're doing and have experienced this process, because it's not like any other process. It's not like your regular civil lawsuit or criminal case or family law case. It's very unique. Next slide. Alternates. Let's talk about these. What can we do? What are some things available that can try to help us prevent a guardianship? The first one is proper estate planning documents. This is one I see more than anything else, is that people don't put documents in place before they need them. I get a call and I get this call all the time. I just put mom in a memory care unit and I need to bring mom in to do a power of attorney so I can take care of mom's bills. And I often have to say to them, well, I have to assess mom, but if you just put mom into a memory care unit, I can pretty much tell you that means mom's mindset is no longer of the capacity to be able to sign these documents anymore. Mom has to know what she's signing and what they're doing and what the purpose of these forms are. And if mom or dad doesn't know that, they can't sign these documents. And so executing estate planning documents always needs to be done when you don't need them. And then that's the hardest part of us, telling people is you need to get people in to do them ahead of time so that they're in place when that time comes. Some of you all that may have listened to this presentation or listened to me speak before have heard of kind of my story, but I was a 42-year-old trial attorney working like a dog, fighting a disease called ulcerative colitis. My disease got so bad that in 2006, they had to remove my colon. And when they did, they messed up and my intestines ruptured and I almost died. I was in critical condition for 10 days. I was in the hospital 37 days the first time, and I was in and out of the hospital for over 8 months, had to have 6 surgeries, the last 2 in Cleveland at the Cleveland Clinic. During that time, I was out of work for over 8 months. During that time, I was incapacitated. I could not take care of myself. I could not take care of my person. I could not take care of my finances. And I did not have any of my documents. And the difficulties I put on my family because I didn't have my documents in place, it was unreal. And that's really a lot of why I do what I do, is because I don't want people to go through what I went through and what my family went through because we didn't have our documents in place. And having proper documents in place changes everything. We have documents that we can do for our clients that can help avoid guardianship altogether. If they're properly drafted and they're properly put in place, we call it the family and money protection plan that we put together because it protects the person themselves, it protects their family, it protects their money. Those things can avoid a guardianship outright. If you want to know anything more about that or have any questions, we'll be more than happy to talk to you about that. But that one I cannot emphasize enough. You got to do your documents. You can appoint a designated representative or a representative payee for Social Security, SSI, SSDI, VA benefits, etc. That person can be the one responsible for getting the money and managing it and paying bills. That helps tremendously. Have caregivers that sometimes can postpone a guardianship if you do have somebody that'll take care of it. A lot of these alternatives really revolve around the ward, the person that would be the ward, cooperating. And if they don't cooperate because their mind's not right, then it makes a lot of these alternatives difficult. There are money management programs in Texas that are available. Next slide. You can establish a joint bank account. And again, this is one of those, there's good and bad about that. Some of my families, I tell them that's a horrible idea because of the situation or the finances of the family. Some families, it works out pretty good. Mine, it works out good because my mom doesn't have a lot of money. She didn't save. She and my dad weren't good at saving. So my mom is pretty much living on what she gets every month. And so for me being a joint on her bank account, that makes it to where I can pay her bills and I can take care of the money. And there's not a real big liability on me or her. So sometimes it works, sometimes it doesn't. You can take advantage of certain community services. We do have a lot of community services around here, like home delivered meals. We do a lot of work with Meals on Wheels to try to help people and keep them nutrition without having to go through a guardianship. And there's some supported decision-making agreements that can be entered into. That's a little bit more complicated subject, so I'm not going to really go into it, but that is available. You really need to speak to an attorney about that. Next slide. There's management of community property. That comes into play quite often when you have a healthy spouse and a not healthy spouse. There's eligibility for Medicaid waiver programs that are handled by the Texas Department of Aging. There's determine if the incapacitated person is eligible for Medicaid. We do a lot of Medicaid and VA benefits through our firm to try to help people get Medicaid and VA money for long-term care. And quite often, if we can get that done, they can be put in a facility and taken care of without having to go through a full-blown guardianship. Services through the local area agency on aging and also adult protective services. Next slide. So why do you want to avoid the guardianship? I think you probably have a good idea already by what we've talked about, but let's just wrap it up with a couple things. You want to avoid it because it's expensive, it's humiliating, it's time consuming. And this is one thing I have not talked about. It's a public process, meaning everything that happens in court is public record. So everything that's filed in court is public record. They have passed some laws that limit access to some of the guardianship paperwork that's filed, which is nice. It makes it to where not everything in a guardianship is public record, but a lot of it still is. And what does that mean? Public record means anybody can read it and take advantage of it. And that's where people get scammed on by predators and creditors. The probate process, when somebody passes away and you have to file probate, probate a person's will, etc. Public, meaning everybody can read it. Anybody can get in there and take advantage. So we do a lot of warning of our clients that you're going to be scammed on. You're going to get a lot of junk mail because of this public nature of the process. It gets courts, attorneys, courts, and the government right in the middle of everything. One of the reasons I became an attorney is because I don't like attorneys. So I was a cop before I was an attorney, and I dealt with them on that level. And so some attorneys are good, some attorneys are not so good. Some attorneys are deal makers and some are deal breakers, and some make the process easier and some make the process a heck of a lot harder. And I used to hate when I was actively practicing guardianship cases. I hated it when the attorney on the other side wasn't a experienced guardianship attorney. It just made it a nightmare. The courts, again, we've talked about that. Some are good, some are not so good. If you're in Collin County, we have one of the best probate courts around. There's complaints that come out of Dallas. There's complaints that come out of some of the other courts. It just all depends on where the court is and who the judge is at the time. And just about the time you have a good judge, there's an election and we get another judge. And now we don't know whether that judge is going to be any good or not. And then again, the government issues that come involved. And it is the most restrictive measure of all measures. We talked about that. Next slide. So the fact that the person can lose their basic rights, and again, it removes some civil rights and privileges that a person has. That's really is a part that I don't like about it, but it's necessary because we have enough crazy people voting. We don't need somebody that's been medically diagnosed to not making smart decisions to be able to vote. So that's just kind of one example, but there's a lot of restrictions that come on that person and a lot of things they lose. It can deprive them of intellectual and physical incapacities and disabilities, the right to make fundamental decisions. So when you put a person under guardianship, you take away a lot of their right for decisions. I deal with that with my mom. My mom's, we're technically not a guardianship, but I make a lot of her decisions, and I have to completely remind myself often, I need to let my mom be involved in some of these decisions that affect her. I go out of son mode and I come into attorney mode or caregiver mode, and I start doing and making decisions without my mom being able to have input. With a guardianship, the ward technically doesn't have input unless the guardian gives them input. And that can be a difficult or a sad thing. And again, it can affect family members being no longer involved in the process. They may no longer have any decision-making ability whatsoever, and they may have limited access to the person depending on the circumstances. Next slide. This slide is a few resources that are out there that you all might want to go to. Some of these websites, like there's a Texas Guardianship Organization, there's a National Guardianship Organization, there's some organizations in Dallas. So I think you'll find that these resources are very helpful if you're looking for information. Now, I have talked long enough, and I know you guys have asked a lot of questions, but next slide, Marty. We're gonna kind of turn it loose for the rest of the time that we have and let you all ask any questions. If you want to ask them verbally, let Marty know and he can unmute you, I think.
Actually, we're going to ask you to ask him in the Q&A if you would.
Okay.
It gets pretty cumbersome to try to.
Yeah. While we're looking at that, are there any questions that have come in the Q&A that you think everybody would benefit from hearing?
Yeah, there's been a couple actually. Sandy asked, does Senior Source handle things outside Dallas County? And I was holding off on answering that. I believe they do, Sandy, but I am not sure about that. So if anybody is aware specifically of that and whether the Senior Source handles things outside Dallas County, if you could put that in the chat, that would be helpful. Again, I believe that they do, but I haven't had occasion to work with them outside of Dallas County, so I'm not 100% positive on that.
Well, and I want to address one that just came in because this is a very common one and it's a very kind of tricky one. I'll address it and then I'll let Jeff chime in. But the question came in from Araceli. Can a person with severe bipolar or mental illness be granted a guardianship? And the easy answer is it depends. I have my experience with mental illness is that the courts do not like to grant guardianship for people with mental illness, that there is medication or things that can be taken that can control that mental illness. They don't like to go to the absolute extreme of guardianship if that person can be cared for other ways. I found that extremely, extremely frustrating. I had a case where severe bipolar, and of course, sometimes she would take her meds, sometimes she wouldn't, but more often than not, she wouldn't. And like a lot of people in those conditions, they'll take their meds until they're feeling better. And then they get to, well, I don't think I need them anymore. And then we go right back in. And I found that the courts did not want to grant guardianship on those cases more often than not. Jeff, what has been your experience on that?
Jeff, I think you're muted.
Yeah, sorry about that. I was trying to get to my unmute button.
Okay.
My experience is similar to that. I actually just got retained by a family, a mother and father whose daughter is paranoid schizophrenic and is in the process of being admitted to a mental hospital. And I think that those kinds of cases really lean more towards temporary guardianship, because oftentimes we can get in there, we can get temporary guardianship to try to do things like, in my situation, there's a house that needs to have the mortgage paid. Mortgage payments aren't being made. Mom and dad don't have the ability to do that. We want to be able to preserve those kinds of things. So that's a situation where we get temporary guardianship, and hopefully the daughter gets into where she needs to be. She gets her medications managed, and she really doesn't need that anymore. And then we can just dissolve the temporary guardianship. So there, again, it's going to depend on the county that you're in and how the judge looks at those. Some judges, again, are more restrictive on that than others. So it really just kind of depends on that situation. I've got a question here from Joan. Joan asks, is the process of guardianship simpler for individuals who have had lifelong intellectual or developmental disabilities and who recently turn 18 and want their parents to be their guardians? Yes, it is a little bit simpler. The process is the same, but typically if we're doing what we call an age-out guardianship, it is a much more streamlined process. And again, it's going to depend on the county. There are some counties in Texas where the judges, even in those kinds of situations, really hesitate to get guardianship in place. They want to see a lesser restrictive alternative. But other courts are very open to that. The age-out guardianship process is fairly easy. The process of getting it in place is still the same, but it's a lot of times a much more streamlined process. So that happens frequently. We have situations, where you have a child with Down syndrome, for example, and now that child is 18 and they need to have a guardian appointed. So it does happen fairly frequently.
And I think one of the reasons they're usually easier is I personally haven't had a case, and I don't know if you have, Jeff, but they're simpler because the person that's going to be the ward usually doesn't contest it. Their mom and dad's been taking care of them forever. If they understand the process at all, they're like, yeah, I want mom and dad to keep taking care of me. So it's a very cordial atmosphere rather than a contested atmosphere.
And then along those lines, LaDonna asked, for those who have severe IDD and they're nonverbal, is guardianship the only option, or would a power of attorney be appropriate? The problem, LaDonna, with powers of attorney is that in order to sign one, you have to have sufficient mental capacity to do so. And so if you've got a person whose capacity is already compromised, it's virtually impossible to get a validly signed power of attorney. And so in that situation, guardianship really, subject to there being less restrictive alternatives, the guardianship is really the only option at that point. So unfortunately, POAs aren't really much of a saving grace in that scenario.
I saw a question that came in much earlier from Carol. Says, I have a client in a very difficult family situation. The sister to the ward has guardianship of the person, but the ward hates the sister and is abusive. Sister told us she told the judge she was going to resign, but the judge told her she could not.
It's one of those situations where, unfortunately, you're a little bit at the mercy of the judge that's handling the guardianship. If you have, the way it should work is if you have a situation where the guardian wants to resign, then that should be allowed, and that there should be a successor guardian appointed. Sometimes that happens in a death situation. You'll have the existing guardian passes away or themselves becomes incapacitated, and then you have to go back to court and have the court appoint a successor guardian. So I'm not sure why or what reasoning that particular judge was using, to oppose the resignation of the guardian in that situation. One thing that would be possible perhaps is to, have a motion filed to reconsider that decision, and perhaps have a full-blown evidentiary hearing on it to try to get to the bottom of what's really going on there. So it's hard to answer in the abstract, but the judge who has control of the case, unfortunately, has a lot of discretion. And I say unfortunately because sometimes you run into judges that you think are not making the kinds of decisions that the court would suggest that they should make, and it's sometimes difficult to overcome that.
Also, oh, sorry, go ahead.
So Jill has asked, we've had some discussion in the Q&A going back and forth about consistency among the counties in Texas, and her latest question is, how can I advocate for more consistency among the counties? unfortunately, the legislature is the one that passes the Texas Estates Code and any amendments to that. If there are particular issues that are coming up frequently, oftentimes you'll see the bar, the probate and guardianship bar, go to the legislature with suggestions for revisions of the statute. And of course, you always have the electoral process because all of these judges are elected officials. And so, if you've got a situation where you've just got a really unworkable judge, maybe the answer is to go to the ballot box. Not a very great answer, Jill, but there is, there are some things that can be done, but you only have so much that you can do.
I did like one of the responses, Jeff. One of the attendees responded, get involved with the Texas Guardianship Association because they advocate. I think that's a real good suggestion.
I agree with that. Okay, next question, Wendy.
An earlier question, Jeff, that y'all may not have seen in the chat. When Fred talked about how if you move the ward to another state, then you have to start the process in that state. Regina wants to know, does that related to moving counties within the same state?
Well, I can address that because I've actually got cases like that going on right now. So each state has a different framework for guardianship. Some states call it conservatorship, others call it guardianship. I just had one of my wards move out of Texas to Massachusetts. And so now I'm working with Massachusetts Council to get the guardianship transferred out of Texas to Massachusetts. There's a process for that. It's fairly streamlined. It's really not terribly difficult. You basically file a motion to have the court transfer the guardianship from one state to the other. The other court receives it and kind of picks up where the Texas court left off, so to speak. Intra-county guardianships, intra-state transfers of guardianships is even easier. If you have a ward, for example, that relocates from Collin County to Victoria, again, you file a motion in the Collin County court, the court grants the motion, transfers venue of the case to, South Texas, wherever it is, and it's usually a fairly simple process. Let's see, I just have a
question, Jeff, real quick on the kind of a typical cost of doing an aging out guardianship. Can you kind of just address that real quickly?
Yeah, I think you and again, it's going to depend on who you use, but ordinarily, I think you should look at spending $1,000 to $1,500. I think that's typically where we find ourselves. It's a fairly simple process. It's almost always uncontested. You usually never have a situation where the attorney ad litem that's appointed thinks that anything other than having a guardian for the now majority ward be appointed. So they're usually pretty simple cases, pretty straightforward. So that's a decent ballpark, I think, of the cost associated with those.
Well, but to clarify, that's usually the legal fees. That's not the ad litem fees, the court costs and everything else.
Correct.
So you add it all together, I think you're probably looking 3 to 5 is probably a safe number to do. It's probably maybe not that much, but just to be safe, I would tell families, you're probably looking about $3,000 with all the costs involved. Jeff, we have any other questions that you saw?
Yes. So Mary Anna asks, where can we find assistance for guardianship fees? I work with IDD pediatrics and a lot of lower income and have issues with this all the time. There are processes that are in place that allow indigent wards and families that don't have a lot of money to get assistance from the county with things like filing fees and ad litem fees. You can petition the court to have the county pay for those kinds of things. When it comes to the legal fees involved, unfortunately, there are really not a lot of programs, at least that I'm aware of out there, that provide funding to folks like me and Fred, private attorneys who provide guardianship services. Sometimes we do those in our office pro bono, depending on the circumstances. There are also organizations out there. Legal Services of North Texas is one that provides pro bono legal services for families that need various legal help. So I would encourage you to look at those. So there is help out there, but it is a problem. There is, unfortunately, as with many things, there is a lot of need and not always as many resources as we would like. Wendy says, my son turns 18 next month and has autism. Do the costs still apply in these situations? Unfortunately, the costs of getting the guardianship in place do exist. There's really, unfortunately, no way around those. Ideally, though, in a situation like that, if he's receiving Social Security assistance, you can become representative payee. And if he doesn't have any assets that need to be managed, then you don't have to be the guardianship of the estate. So there really isn't any ongoing cost to being the guardian of the person. You have to file the report that Fred mentioned earlier with the court each year to basically let the court know how the ward is doing. But other than that, there really isn't any ongoing cost in that situation, Wendy. So obviously, if you have specific questions or would like some additional guidance, let us know. But if he has autism and he really doesn't have an estate per se that needs to be managed, then getting guardianship of the person should be sufficient. And other than the checking in with the court every year to get your powers renewed, there really isn't any ongoing financial cost for that. Sandy asked me, I have a client in Rockwall County. How are things handled there? Sandy, I have to be honest with you. I have not had a guardianship in Rockwall County. We've done probates there, but I have not been in front of that particular court with a guardianship issue. My gut tells me that it is probably a little bit more by the book, if you will. My experience in counties outside of Dallas, Tarrant, Denton, Collin is that the judges there, number one, they're not dedicated probate judges. They're courts of general jurisdiction. So they don't see these issues come up as much as you see in the urban counties. So they tend to follow the code fairly stringently. I know I have cases in Wise County right now. That's been my experience there. So I would suggest that you reach out to someone in Rockwall County that's practiced guardianship work. If we have occasion to be in that court, we obviously become familiar with that court's requirements. But as I sit here right now, Sandy, I haven't had that experience. So unfortunately, I can't give you specific guidance. Doris asks, does a supportive decision-making agreement in Texas require an attorney? I don't believe that it does. It's always a good idea to have attorneys involved when drafting legal documents like that, but I don't think it's statutorily required. And there are, she shared a link in her question and the answer that I'll copy and paste into the chat that might be helpful. Kelly asks a question around being representative payee for Social Security. She says, is there any preference to being a joint owner on a bank account versus being a payee for Social Security? The problem that we run into with joint ownership of bank accounts is that first and foremost, each of the people on that account are deemed to be an owner of the account. So they have theoretically the complete ability to transact business in that account, including liquidating that account. And so if you don't have a situation that's stable and you have joint owners, that can be a problem. The other thing that we've seen that can be a problem with joint ownership is that your assets in that account are subject to the other joint owner's life issues. So for example, if you have a joint owner on an account and they get sued by a creditor and that creditor gets a judgment against them, the creditor can go get the assets in that jointly held account to satisfy that creditor's debt. And so that obviously becomes a problem. If there's a divorce, that joint account becomes subject to potential access by the future ex-spouse. So there are issues with that. There can also be issues with joint accounts when you apply for government benefits like Medicaid. Medicaid treats joint accounts as held 100% by the joint owners. Sometimes that can present a problem. So I always encourage people to look at options other than joint ownership if there are there. And I will tell you, based on my experience, that the Social Security is going to require a representative payee if the individual to whom the benefits are being paid doesn't have capacity. So it's really not a matter of what you would prefer. If the person who's receiving Social Security cannot manage their finances, then they're going to have a representative payee appointed. Sheila, is there anything in the chat that we haven't addressed? I'm really focusing on the Q&A.
I'm looking at one right now while Sheila's looking about, is it right for someone's client to turn around and become a guardian to this someone with the knowledge of an attorney? Will that not be a conflict of interest? Yes. I think you most definitely, just with that limited information, you really want to watch out for conflicts of interest. For instance, we get people that come into our office that ask us if we would be the guardian or if we would be their trustee, and we always tell them no, because we're the ones representing the client, drafting the documents. Even if there's not an outright conflict of interest, any perception of impropriety is enough for us. So I don't even want that perception. So yeah, I would say that is sounds like a conflict of interest.
All right.
I'm going to jump in here. I'm just going to move the slide to the last slide here. But I do want to say, I know there's people that are logging off as we're still answering questions, and there's still a lot of people on, but for the sake of people that are logging off, we're going to be sending out the follow-up email to this, but it will not go out till tomorrow morning. I am leaving as soon as this is over to catch a plane, and so that follow-up email will go out tomorrow morning to you all. It will have the CEU information and the information about next month's webinar and how to register for that. But again, please look for that tomorrow.
Jeff, I just got one. One I'd like you to address. It says it's from Doris. Does support decision making in Texas require an attorney? I send my members to this link, and she gives the link all the time. It looks like it just requires a notary. Do you know anything about that link? It looks like TCDD government.
Yeah, I actually just cut and pasted that from the Q&A session that we had with Doris. I just wanted to share that link with everybody. Courtney, I think you're right. The form itself doesn't require an attorney to prepare it. As I mentioned before, it's always a good idea to have attorneys prepare documents just to make sure that they comply. But Courtney also mentions that there is a standard form on the HHSC website as well. So I think between the two of these resources, that will be helpful. We just had a question come in. When should a representative payee be established? Typically, you'll want to do that when you get Social Security started. If that person is already compromised from a capacity standpoint, you'll want to go through the representative payee process as part of that initial benefits application process. But if you have someone who's already receiving Social Security and then they become incapacitated, then there is a process and forms that you would then fill out with Social Security to have a representative payee designated in that scenario. So again, if you're like my brother and you've always been incapacitated, then when you apply for Social Security for them, you're going to go through that process initially. But if that happens after the fact, then you just go through the process at the point when it becomes necessary.
So Marty, are you going to abuse all of us and tell us what beautiful place you're flying off to that we could go to?
I'm actually flying home from St. Petersburg, Florida. And so we've been here for just about a week to try to sneak in a vacation when all the kids are available. As they grow up, they become more and more difficult to get them all together. And we were very fortunate to be able to get them all together. But this week was the only week that worked. So
I hope you had a great time.
Thank you so much.
Thank you for not taking this call from poolside and making us all
Hey, I want to remind everybody, hey, first of all, thank you, Fred, and thank you, Jeff and Sheila. Thank you so much. I mean, this once again is just incredible information. Obviously, you know, by the sheer numbers, you can see how many people are interested and can use the information. And so these are just incredibly valuable. And I really, really appreciate the partnership with you all. I want to remind everybody that not only I had adjusted the time for today's webinar earlier because of my flight, that I knew I had an issue. Next month, we're going to go back to our regular time, which is 10 to 11:30, just so you guys are aware of that. But is there anything else you guys like to throw in before we sign off?
I think we've been pretty thorough today, and I love the questions. Thank you, guys. If you have any questions after this, the reason we put our information on these slides is so that you can reach out to us after the fact if you need to. We love being a resource to people. You know, we are a very different law firm than most. We are a faith-based law firm, and our job is to faithfully serve God, our clients, and the community in every way we can. And we do that by helping in any way we can. So if you just have questions, if you need some guidance, give us a call and we'll send you in the right direction.
Well, I wanted to touch on that too, because we just want to help you do your job so that you can take care of our seniors. Please use us as a resource, because anytime we can help you with education to help them, that's a double win for us, and we're very, very happy. And if you'll look at next month's webinar, oh wow, this is a powerhouse. And there's going to be someone, the mediator on here, you're going to recognize very immediately. And so she and Fred are going to do this, and Jeff is going to be involved because Jeff does our contested things. So this is a very sad topic, and actually is the reason that Dee became a mediator, because she is an attorney. That's the reason she became a mediator, because of all the family fighting. And if there's any way that we can give you information, and anybody interested in that can help avoid some of this, then that's a triple win there. So that's it.
And thank you, Marty, for everything that you do. Have a safe trip back.
Hey, thank you all. Thank you all so much. This was really incredible, y'all. Very, very good. I know I say that, but I mean, this is really, really good stuff. Thank you. I will add, you guys put it in such a way that's very easily understandable by everyone. And I've heard that over and over and over again on this whole series. So thank you very, very much.
Our pleasure. Our pleasure.
Well, everyone, thank you for joining us, and y'all have a wonderful day.
God bless you guys. Bye-bye.
Thank you.